what are initial disclosures? Pursuant to Rule 194.2 of the Texas Rules of Civil Procedure, initial disclosures are a type of discovery response that are due within the first 30 days of when a party files a counterpetition, a waiver of service, or an answer in any type of civil law case, which includes family law. So if you have an original divorce, an original suit affecting parent-child relationship, or a modification in either a divorce or a SAPSR case, you can expect to have to provide initial disclosures to the other side of your case within the first 30 days of either you filing a response, or if you are the petitioner, the other party filing a response. What are the contents of initial disclosures? In a divorce case, there are going to be 4 main pieces of information or documentation that you are going to be asked to provide to the other side. And this is going to be true whether you are a pro se party or whether you're represented by counsel. In a divorce, these 4 main pieces of information are going to be any deeds or lien information on any real property that you or the other party own, all statements for any pension plan, profit sharing plan, or employee benefit plan, any type of retirement plan that you participate in or that you are the beneficiary of, all statements or policies for any current life, liability, or health insurance plan, and all statements pertaining to any account at any financial institution, including banks, savings or loan institutions, credit unions, or brokerage plans. So in short, your bank statements. And those documents are going to have to be provided from the time of filing of your case for the prior 2 years. In child support cases, so whether it's a divorce or a SAPSR, but if child support is going to be at issue, what you're going to have to provide are information regarding any health insurance benefits that are available for your children or that your children are currently covered by, your income tax returns for your previous 2 years, or if you don't have your income tax returns, then W-2, 1099, or Schedule K-1, so essentially any tax documents that prove your income, and your 2 most recent payroll check stubs. So these are the physical documents that you're going to have to provide. In addition to physical documents, you will also have to provide the correct names of the parties to the lawsuit, any potential witnesses that you might have, any potential third parties who have relevant information about your case, and any evidence that you may have that you may want to use moving forward. So text message exchanges between you and the other party, photographic evidence, videos, anything that you have that may be relevant to your case. Part of initial disclosures is also going to be stating the legal and factual bases for any claims that you're making or anything that you're requesting within your petition. So for example, if you are requesting spousal support under Chapter 8 of the Texas Family Code, your attorney will state that you are requesting spousal support and then will isolate the elements of the statute that prove that you are entitled to that spousal support. It's just an example. Disclosures are due within 30 days of filing any type of response. And you may be asking, well, seems kind of complicated, or that seems like it's going to take a lot of time to provide these responses. Is there any way around it? The answer is yes, but in some cases that are perhaps fairly simple. So let's say that you're getting a divorce and you guys really don't have a lot of property in common, or you feel like you're going to come to an agreement pretty quickly. You've already discussed the bases of an agreed final degree of divorce. You may not want to exchange initial disclosures because it truly may not be necessary. In that case, as long as both parties agree, you can file a Rule 11 or enter a Rule 11 to waive the initial disclosure requirement, which essentially means that you and the other party are saying, hey, we just don't feel like it's necessary to exchange this information because we think that we're going to come to a resolution outside of court. So we don't want to spend the time, the funds to get all of this stuff together to send to the other side. And as long as a Rule 11 agreement is filed and you and the other party agree, you are certainly welcome to do so. There is nothing in the statute that says that you must provide them if you don't feel like you have to. You can abate initial disclosures or extend the initial disclosures deadline. So if you are working on an agreement and you think that perhaps you don't need to exchange this information at the outset, or the parties think that they have an idea of what the other side has, or you have the same information, you can agree to say, okay, we're just not going to exchange this information for, instead of 30 days, 60, 90 days, or indefinitely, until one party says, you know what, I've changed my mind and I do want this information from the other side. And once that party has reinstated the initial disclosures deadline, then both parties have to adhere and they do have to exchange that information with one another. Initial disclosures are not due in every single family law case. Now, at the beginning, you'll remember I mentioned that typically in most divorces, in any original suit affecting parent-child relationship or modification, that initial disclosures requirement, that deadline is going to kick in within that first 30 days. There are a handful of situations in which initial disclosures deadlines are not triggered after a responsive pleading is filed. Those are going to be protective orders, any suit that's filed by the Office of the Attorney General, so any suit that is in 4D court, typically these are child support cases, actions including domestic violence, and petitions for habeas corpus. In conclusion, initial disclosures are basic information that you and your opposing party are going to exchange within typically the first 30 days of a suit being filed and an answer or other type of responsive pleading being filed by you or by the other party. These are required exchanges required by Rule 194.2 of the Texas Rules of Civil Procedure, and these are going to be due regardless of whether you are represented by counsel or whether you are pro se. Here at Varghese Summersett, we have tremendous experience providing and evaluating initial disclosure responses, and we would be happy to help with any questions you may have. Thank you for watching. If you have any questions or comments, you can leave them down below. Otherwise, you can find us at familytexas.com.